guys, so long time no see. I really enjoyed my summer vacation. I hope you guys too. And ito na naman tayo sa aral. But honestly, ginusto naman natin to. And awa po ng Diyos, napasa ko po lahat ng subjects ko last semester. I hope you guys too. And also in watching my videos, I hope nakatulong sila sa inyo sa pag-review niyo for your law studies. So in this video, we'll be discussing under criminal law. It's sort of a recap, it's sort of a review of the concepts we already came across from Crim 1, Crim 2, and this is actually for my criminal procedure class kasi sinabi ng professor namin, it's included in the syllabus na lahat ng concepts na to we should remember by heart. So it's a short review of the concepts we already learned in our previous year. So let's begin. So first is the concept of criminal procedure. So criminal procedure treats of the series of processes by which the criminal laws are enforced and by which the state prosecutes persons who violate penal laws. It regulates the steps by which one who committed a crime is to be punished. While criminal laws define crimes and prescribe their punishment, criminal procedure lays down the processes by which an offender is made to answer for the violation of the criminal law. So if in Crim 1, pinag-aralan natin what is a felony, what are the mitigating circumstances, justifying circumstances, etc. In criminal law 2, we studied the elements of the crime. While here, we are gonna study yung process ng paano mapapunish yung mga nag-violate ng mga laws. So the procedure starts with the initial contact of the alleged lawbreaker with the justice machinery, including the investigation of the crime, and concludes either with a judgment exonerating the accused or the final imposition of a penalty against him. So it has the task of balancing clashing societal interests, primarily between those of the state and of the individual. The ultimate goal is harmonizing governmental functions of maintaining and promoting law and order, while at the same time protecting the constitutional rights of the citizens. Kasi syempre, kahit na we want to enforce the law, we want to punish those wrongdoers, they still have their rights. That's why we studied in our Consti 2, diba? Na there are rights of the accused which should be given importance. So next is we go to the systems of criminal procedure. So the system of procedure in our jurisdiction is either accusatorial or adversarial. So it contemplates two contending parties before the court, which hears them impartially and refers judgment only after trial. The system has a two-sided structure consisting of the prosecution and yung defense, where each side try to convince the court that its position is the correct version of the truth. So we have nga yung sa screen adversarial, wherein the court is active, and accusatorial, wherein the court is passive. So in the accusatorial system, yung court has a passive role and relies on the evidence presented by both sides, in prosecution and in defense, to action in order to reach a verdict. So yung prosecution goes for indictment and yung accused presents evidence para nga sa defense. Sa adversarial system naman, on the other hand, dito daw, active daw yung court. It should be distinguished from the inquisitorial system, where the court plays a very active role and is not limited to the evidence presented before it. So here, yung court has an active role and yung judges nag-gather sila ng facts and mga evidence. So we go to the most basic one. So what is a crime? We studied this in our Crim Law 1. So a crime is an act committed or omitted in violation of a public law forbidding or commanding it. Next is what is an offense. So crimes under the RPC are called felonies, although it is not wrong to call felonies as offenses also. On the other hand naman, yung crimes that are penalized by special penal laws are termed as offenses. But they cannot be called felonies. Offenses lang yung mga crimes na under special penal laws. So what is a complaint? A complaint is a sworn written statement charging a person with an offense subscribed by the offended party, any peace officer, or other public officer charged with the enforcement of the law violated. So next is what is an information. So basically, it's a document prepared by prosecutors upon which criminal charges are brought. Like a complaint in a civil case, an information must contain the pertinent details for a defendant to be able to understand what the charges are and being brought against them. Kasi syempre constitutional right nila na malaman kung anong crime na nakomit nila and what are the charges that are filed against them. So next is, what is jurisdiction? So jurisdiction in general is the right to act or of the power and authority, or the power and authority to hear and determine a cause. It is a question of law. So specifically, it is the authority to hear and try a particular case and impose the punishment for it. So sabi, may tatlo daw na aspects ng jurisdiction in criminal cases. First is jurisdiction of the subject matter, second is jurisdiction over the territory, and third is jurisdiction over the person of the accused. So sa first one, sa jurisdiction over the subject matter, it refers to the authority of the court to hear and determine a particular criminal case. It is jurisdiction over the offense charge. So sa second one naman, sa jurisdiction over the territory, it refers to the territorial jurisdiction of the court in relation to the place where the offense was committed or any of its essential ingredients should have taken place. So for example, yung accused na huli siya sa Martina, tapos na-raffle yung case niya sa Rizal. So yun yung jurisdiction over the territory. So jurisdiction over the person of the accused refers to the authority of the court, not over the subject matter of the criminal litigation, but over the person charged. So next is we go to venue. Venue is an essential element of jurisdiction in criminal cases. It determines not only the place where the criminal action is to be instituted, but also the court that has the jurisdiction to try and hear the case. So may twofold reasons though for this rule. The first is that the jurisdiction of trial courts is limited to well-defined territories, such that a trial court can only hear and try cases involving crimes committed within its territorial jurisdiction. So territorial siya. The second reason is laying the venue in the locus criminis is grounded on the necessity and justice of having an accused on trial in the municipality or province where witnesses and other facilities for his defense are available. So next is we go to warrant of arrest. So an arrest warrant is an official document signed by a judge which authorizes a police officer to arrest the person or people named or described in the warrant. Kasi, di ba, our laws allow John Doe warrants kasi usually other criminals has aliases. So you can't really say na kumare si Juan de la Cruz, sigurado kung si Juan de la Cruz talaga pangalan niya. So John Doe warrants are more like i-describe yung person of the accused. And yung warrant of arrest, it can be it can be just describing this person ng parang hindi naman particularly na yun yung pangalan niya. For the issuance of arrest warrants, we already studied this in our constitutional law too, but reviewing is first, there must be an information filed by the prosecutor recommending the trial of the accused. Second is the existence of probable cause, paulit-ulit yung probable cause, as determined personally by the judge. And third is particular description of the person sought to be arrested. Ito na nga yung sinabi ko na parang description niya kung hindi man alam talaga yung tunay na pangalan niya. So next is we go to search warrant. So a search warrant is an order in writing again issued in the name of the people of the Philippine Islands, signed by a judge or a justice of peace, and directed to a peace officer commanding him to search for personal property and bring it before the court. So for the issuance of search warrants, again a review, first is there must be an application under oath or an affidavit, which must refer to the truth of the facts that are within the personal knowledge of the petitioner and his witnesses. Second, in the determination of probable cause, the judge must personally examine in the form of searching questions and answers under oath or affirmation the complainant and the witnesses he may produce. Third is the existence of probable cause as determined personally by the judge. Fourth is the warrant must be issued in relation to one specific offense. So kailangan isa lang yung specific offense, hindi pwedeng ang dami yung offense, tapos isa lang yung search warrant. Fifth is the warrant must particularly describe the place to be searched and the persons or things to be seized. So for I already discussed this in another video, but to recap nga po, kung sinabi na sa 10 Sampaguita Street yung nasa search warrant, hindi sila pwedeng mag-search dun sa, kung hindi nila natagpuan dun sa 10 Sampaguita Street, hindi nila pwedeng i-search yung 5 Sampaguita Street kasi yung nasa search warrant is 10 Sampaguita Street. So it has to be particular like that. So next is a public prosecutor. So the public prosecutor in the Philippines is actively involved in the investigation of crimes and can commence an investigation upon receiving a report from a law enforcement agency or a private party. So they are officers of the government whose function is the prosecution of criminal actions, partaking the nature of criminal action. So he is also referred to as public prosecutor or usually fiscal, di ba tawag natin sa kanila. So he is also a quasi-judicial officer. Ano naman yung private prosecutor? So a private prosecutor, in case of heavy work schedule for the public prosecutor or in the event na may lack ng public prosecutors, the private prosecutor may be authorized in writing by the chief of the prosecution office or the regional state prosecutor to prosecute the case subject to the approval of the court. So next we go to counsel depart. So counsel depart is an attorney retained by a party litigant, usually for a fee, to prosecute or defend his cause in court. It implies freedom of choice either on the attorney or the litigant. So what is a public attorney? So subject to existing rules and regulation, public attorneys shall assist or represent free of charge indigent persons and other qualified clients in all civil, criminal, administrative, and quasi-judicial cases. So ito yung PAO, yung Public Attorney's Office natin, di ba? Sobrang busy ng mga tao na yan. So next is mediation. So mediation means a voluntary process in which a mediator selected by the disputing parties facilitates communication and negotiation and assists the parties in reaching a voluntary agreement regarding a dispute. So ito yung pag may mga amicable settlement, ganyan. So what is a preliminary investigation? So yung preliminary investigation is an inquiry to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. This is the usual route taken for initiating a criminal case where the respondent or offending party was not arrested without a warrant because none of the circumstances allowing warrantless arrest is present. So warrantless arrest takes place when a person to be arrested is caught committing, about to commit, or has just committed a crime. We'll discuss this more later. Ano naman yung penalty? So penalty is the punishment imposed on a wrongdoer. It can be in the form of imprisonment or pwedeng fine. It is the sum of money the party agrees to pay or forfeit by way of punishment in case of breach of the contract. So next is probable cause. Ito yung paulit-ulit natin narinig sa Consti and sa Crim Pro. So in general, it means such reason supported by facts and circumstances as will warrant a cautious man in the belief that his actions and means taken in prosecuting it are legally just and proper. So ano ba yung ibig sabihin nito? Na parang yung layman is kahit na wala naman siyang masyadong magets. Charot. Parang ako yun na. Pero yung probable cause is kung wari itong si accused, kahit ako may intindihan ko or kahit ako, I would think na with facts and circumstances surrounding him na siya talaga yung nag-commit ng crime. So what is a motion? So it's a formal request made to a judge for an order or judgment. A motion in its simplest form is a list of requests that you are asking the court to grant on your behalf. Diba? You have motion for reconsideration, motion to quash, mga ganyan. If the circumstances require, your attorney may submit a brief on your behalf, providing the court with the law supporting your positions. So next is what is an arrest? So kanina sinabi natin yung warrant of arrest. So an arrest is the taking of a person into custody in order that he or she may be bound to answer for the commission of an offense. It is effected by an actual restraint of the person to be arrested or by that person's voluntary surrender to the custody of the one making the arrest. Neither the application of actual force, manual touching of the body, or physical restraint, nor a formal declaration of arrest is required. It is enough that there be an intention on the part of one of the parties to arrest the other, and that there be an intent on the part of the other to submit under the belief that an impression that a submission is necessary. So next is what is a bench warrant. So it is a warrant issued by a presiding judge or by a court against a person guilty of contempt or indicted for a crime. So a bench warrant is a warrant of an arrest warrant. It is usually issued when a subject fails to appear for a required court appearance. So next is pre-trial. So pre-trial is a stage of a court proceeding before the trial, obviously. So the importance of a pre-trial is that it allows the parties to explore the possibility of an amicable settlement or a submission to alternative modes of dispute resolution. So tinatry muna na parang before sila mag-trial, tinatry muna kung pwede sila mag-settle na lang. So the pre-trial conference is conducted for the expeditious disposition of the case. So in the pre-trial and preliminary conference, there is narrowing of conflict between the parties. In furtherance of this, the judge is sanctioned to allow the number of witnesses to be presented and limit the trial days. So next is we go to persons deprived of liberty or PDLs. So hindi na daw ginagamit yung term na inmates, but we use now yung persons deprived of liberty. Instead, because those who are still awaiting judgment or undergoing trial, ito nga daw yung mga PDL. So prisoners are those who have already been convicted by the courts. Ito yung mga nag-aawait pa lang ng trial pero na-arresto na sila. So next is the children in conflict with the law. So it refers to a child who is alleged as, accused of, or adjudged as having committed an offense under Philippine laws. So children in conflict with the laws is defined as anyone under 18 who comes into contact with the justice system as a result of being suspected or accused of committing an offense. Most children in conflict with the law have committed petty crimes, some of which are not considered criminal when committed by adults. Pero meron din naman, di ba, we studied in our Crim 1 yung whether they acted in discernment or without discernment, yung mga ganyan. So you have to read upon this also. So next is inquest. So inquest is defined as a informal and summary investigation conducted by a public prosecutor in criminal cases involving persons arrested and detained without the benefit of a warrant or of arrest issued by the court. So the inquest serves to determine whether said persons should remain under custody and correspondingly be charged by the court. So because it is summary in nature, and owing to the attendant risk of running against the periods under which the detained persons must be delivered to the proper judicial authorities. Ito nga yung Article 124, 125, 126. An inquest usually ends with either the prompt filing of an information in court or the immediate release of the arrested person. So next is what is bail. So bail is a mode short of a confinement which would, with reasonable certainty, ensure the attendance of the accused at his trial. So, di ba usually you bail para makalabas ka ng prison or para temporarily kang hindi makulong. So, it usually takes the form of a deposit of money or its equivalent of such attendance and which deposit is forfeited upon failure to appear. The sole purpose of bail is to ensure the attendance of the accused. It has neither punitive or revenue-raising purpose. So next is what is release on recognizance. So recognizance daw is whenever allowed by the law or the rules, the court may release a person in custody on his own recognizance or that of a responsible person. So recognizance is the release of a person in custody of himself or another reputable person. He or that person whom he was entrusted to will be tasked with the burden of bringing him to court when he is required to. Simply put, it is a promise to appear. It is an obligation of record entered into before a court guaranteeing the appearance of the accused for trial. It is in the nature of a contract between the surety and the state. So next is probation. So yung probation, we already studied this before, is a special privilege granted by the state to a penitent qualified offender. So it essentially rejects appeals and encourages an otherwise eligible convict to immediately admit his liability and save the state the time, effort, and expenses to jettison an appeal. So it is a disposition under which a defendant, after conviction and sentence, is released subject to the conditions imposed by the court in the supervision of a probation officer. So yung probation ba absolute right ba to? The answer is no. It is a mere privilege whose granted rests upon the discretion of the court. Specifically the trial court. Its grant is subject to certain terms and conditions that may be imposed by the trial court. Having the power to grant the probation, it follows that the trial court also has the power to order its revocation in a proper case and under proper circumstances. So, di ba, meron ding mga kaso na pwedeng under probation pero hindi sila pwedeng, pero meron din yung mga hindi pwedeng under probation. So next is we go to fines. So criminal fines are penalties imposed on defendants after conviction. So intended as both deterrence and punishment. The amount of a fine is set by a statute and based on the severity of the crime. For misdemeanors, fines may be relatively small, but for felonies, fines are typically larger. So, di ba, depende naman yun sa mga crimes na nakulit mo. Next is community service. So, in the criminal law area, community service refers to a form of sentencing involving an activity that benefits the community to compensate for the harm done. So, yung ginawa ng offender, pagbabayaran yun through community service. So, the object of community service orders is to provide unpaid work which of value to the community as an alternative to custody. So, next is we have appeal. So, what is an appeal? An appeal as a matter of right, which refers to the right to seek the review by a superior court of the judgment rendered by the trial court, exists after the trial in the first instance. So an appeal is a proceeding where a higher forum reconsiders the decision of a lower forum on questions of law and facts with jurisdiction to confirm, pwedeng i-reverse, pwedeng i-modify the decision, or remand the matter to the lower forum for fresh decision in compliance of its directions. So next is judgment. So judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged and the imposition on him of the proper penalty and civil liability, if any. Next, we go to subpoenas. So napag-usapan na natin to sa Constitute. So ano ba yung subpoena? A subpoena is a process directed to a person requiring him to attend and to testify at the hearing or trial of an action or at any investigation conducted under the laws of the Philippines or for the taking of his deposition. So, in this jurisdiction, may dalawa daw na klase ng subpoena. So, subpoena as testificandum and subpoena duces tecum. So, the first is used to compel a person to testify, while the second is used to compel the production of books, records, or documents therein specified. So, in subpoena duces tecum, in all respects, like the ordinary subpoena as testificandum, with an injunction that the witness shall bring with him or produce the examination of books, documents, or things described in the subpoena. So next is order. So what is an order? It is a direction of a court or judge normally made or entered in writing and not included in a judgment, which determines some point or directs some steps in the proceedings. So the decision of a court or judge is made in the form of the order. A court may issue an order after a motion of a party requesting the order, or the court itself may issue an order on its own discretion. So for example, courts routinely issue scheduling orders which set the timetable and procedure for managing a civil lawsuit. So more substantive orders, however, typically are made following by a motion na ginawa ng isang party. So a motion is an application for an order. We already discussed what a motion is a while ago. So next is arraignment. So an arraignment is a hearing. It is where the court formally charges the person who abused you with the crime. A criminal proceeding at which the defendant is officially called before a court of competent jurisdiction. So the accused is informed of the offense charged in the complaint, information, indictment, or other charging document, and asked to enter a plea of guilty, not guilty, or as otherwise permitted by law. So we go back to prosecution. So it is the act of officially accusing someone of committing an illegal act, especially by bringing a case against that person in the court of law. So the prosecution refers to the lawyers in a trial who try to prove that a person accused of committing a crime is guilty of the crime. Yun naman yung trabaho ng mga prosecutors natin. So next we have trial in absentia. So trial in absentia is a criminal proceeding in a court of law in which the person who is subject to it is not physically present at those proceedings. So dito magbabasa ng judgment yung judge nang wala yung accused. That's why it's called trial in absentia. In absentia, the Latin for in the absence. Its meaning varies by the jurisdiction and the legal system. So next is a plea. Ano ba yung plea? It's a formal response by the defendant to the affirmative assertions of the plaintiff in a civil case or to the charges of a prosecution of the prosecutor or the prosecutor in a criminal case. So yung pleas, kagaya ng sinabi ko na kanina, it may be guilty, not guilty, or no contest. Next is certificate of arraignment. So ano ba yung certification na to? So the certification means a judge who heard the preliminary hearing determined there's enough evidence to hold a trial. In some cases, the defendant may waive the preliminary hearing and agree the case can be certified. So next is Bill of Particulars. So ano ba yung Bill of Particulars? It is a written statement used in both civil and criminal actions that is submitted by a plaintiff or a prosecutor at the request of the defendant, giving the defendant detailed information concerning the claims or charges made against him or her para ma-specify ano ba yung nangyayari, ano ba yung charge sa akin. In civil actions, a bill of particulars is a written demand for the specifics of why an action at law was brought. So, ayun. What is moral certainty naman? So, moral certainty only is required or that degree of proof which produces conviction in an unprejudiced mind. So the conscience must be satisfied that the accused is responsible for the offense charged. Ito yung sinasabi nating proof beyond reasonable doubt. Then next is entry of judgment. So the entry of judgment is made after it has become final. So, kumari, upon the expiration of 15 days after the notice to the parties. So, entry occurs after the rendition of judgment and is a ministerial act that consists of recording the ultimate conclusion reached by the court in the action and providing concrete evidence of the judicially imposed consequences. So, it serves as a memorial of the action. Kung kanina yung proof beyond reasonable doubt, ano naman pag sinabi nating reasonable doubt? So, a doubt especially about the guilt of a criminal defendant that arises or remains upon fair and thorough consideration of the evidence or yung lack thereof. So, a defendant is considered innocent until proven guilty, as you know, the general rule. If the judge or jury has reasonable doubt about the defendant's guilt, the defendant cannot be convicted. Simply put, reasonable doubt is the highest standard of proof used in any court of law. And para makonvict mo yung tao, kailangan it's proof beyond reasonable doubt. So next is we go to warrantless arrest. Kanina, arrest warrant, ganyan-ganyan. So ano ba yung warrantless arrest? An arrest without a warrant or a warrantless arrest is an arrest of an individual without the use of an arrest warrant. Malamang. But anyway, there are 3 recognized exceptions to the constitutional prohibition on warrantless arrests. As we studied in our Constitutional Law 2, tatlo yan. First, in flagrante delicto. Pag nakita nung peace officer na siya talaga yung na ginagawa talaga yung crime. A crime is being committed. Yung hot pursuit arrest naman, if you have probable cause, tapos ito yung tuloy-tuloy yung ginagawa yung crime, and you have probable cause na ginagawa pa rin yung crime, you can pursue this person. So, third is the rearrest of escaped prisoners. So, ito yung mga juvenile delinquents. So, next is we have restorative justice. Restorative justice is a process through which remorseful offenders accept responsibility for their misconduct, particularly to their victims and to the community. The restorative outcome of this agreement obtained as a product of a restorative justice process. So next is public crime. So public order crimes are actions that do not conform to society's general ideas of a normal social behavior and moral values. Public order crimes are widely viewed as harmful to the public good or harmful and disruptive to a community's daily life. So basically, ito naman lahat ng crimes, it's really against the public. Kasi kaya nga yung mga cases, di ba, Weird People of the Philippines versus Reyes, People of the Philippines versus Cruz, because it's a crime against the state. Like kahit na rape yan, kahit na murder yan. Kasi it's a public crime because it's a crime against the state, it's a crime against societal norms. So it doesn't conform to our society and it's against public morals. So kailangan yung ma-punish for committing those kind of offenses. And lastly, we have private complainant. So ano ba yung private complainant? Kita natin yan, di ba, minsan, people of the Philippines, so tapos may private complainant. So a private complainant is a criminal action that is initiated by a private citizen rather than a police officer. This complaint is against another person he or she suspects or believes is guilty of a crime and presents an accusation before the proper authorities for investigation. In such a situation also, the complainant may file the complaint in the court, which is also known as private complaint. Thus, a private complainant basically means a complaint which is directly filed by the complainant in the court. So, thank you for listening to my first video this semester. And I'm really touched by the comments you guys leave on my videos na nakakatulong ako. Because sometimes talaga, when studying law, di ba, parang, gets po ba to? Ano pa ba? Am I really for this path? So, it's really, it warms my heart, your comments for this video. And subscribe to my channel and I'll wait for my next videos for criminal procedure. Thank you!